welcome everybody. It's great to have you in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and I'm here with Tom Donnelly, one of our top scholars. And today we're going to walk through battles for equality in America and really look at the meaning of equality from the Declaration all the way through to today's conversations and court cases with the lens of the 14th Amendment. We're going to tell you everything about the 14th Amendment, and we're going to go through some big cases that changed the way our country worked and how we live. So Tom, do you want to say hi to everybody and let us know a little bit about yourself and why you're so excited about the 14th Amendment?
Sure. I'm Tom Donnelly. I am the Senior Fellow for Constitutional Studies at the National Constitution Center. And, more than anything, this is an exciting topic because it allows us to see how the 14th Amendment transformed the Constitution forever and how it's at the core of so many of the debates that we still fight about, care about today.
And a little fun hint, if you're looking at a court case and wondering what amendments or what sections of the Constitution are connected, you could probably almost always find the 14th Amendment in there. That's why it's so big. That's why we spent 2 weeks on it. So let's start with the actual text of the 14th Amendment. And I did a little highlighting on this slide to kind of help us focus because there's so many words and there's about 5 sections. So there's 5 slides on this. So let's begin with section 1, which is the heart of what we're going to talk about today. But if anybody has questions during the class, feel free to put them in the Q&A or in the chat. We're here to help.
That's great, Kerry. And I think here's how I want to take this intro section, if it works for you. I think I'm going to take the text. I'm going to say a little bit about placing it in historical context when this comes into the Constitution, and then end on the 4 big ideas that unify the amendment. Does that sound good, Kerry?
I think that sounds great.
Okay, so let's begin with the text. And, this is a huge wall of text, but I'm actually going to read it because it may be the most important text in the entire Constitution. So I want it sort of echoing in our brains as we have this conversation. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And as a bonus, I will also put in section 5, which is the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, these are really, really powerful words. There's a lot of words, but they are really, really powerful. And they're at the center of so many of the constitutional debates, so many of the Supreme Court cases, so many of the constitutional issues that we care about today. Same-sex marriage, affirmative action, privacy, abortion, even many of the Bill of Rights cases dealing with free speech, religious liberty. Those are attacking state laws that we only reach because of the 14th Amendment. And so there's a way in which the history of the modern Supreme Court could be told in part as a history of modern debates over the 14th Amendment's meaning. It's impossible to overstate how much this amendment transformed the Constitution forever. And so why did the 14th Amendment's framers put these words in the Constitution? What did they have in mind? What did they mean? What were the big ideas? And so really to ground these words, I think it's really important to begin by going back to April of 1865. And so right here, the Civil War has ended. Abraham Lincoln's been assassinated. Andrew Johnson has become president of the United States. And our nation's wrestling with some of the most vexing, some of the most difficult problems since our nation's founding. Should we pardon or punish the former rebels? Should we allow the ex-Confederate states back in? And if so, on what terms? And really the biggest question of all, what duties do we owe the formerly enslaved people? Many of whom fought for the Union Army in the battlefields, laying claim to the promise of liberty and equality, laying claim to the promise of equal citizenship. What did we owe them? And what's so interesting about this moment, Kerry, is, if you're a Reconstruction Republican, it's April 1865, even with Lincoln assassinated, you're feeling pretty optimistic. There were radical voices in the Republican Party that looked at Lincoln as a great president, but to a certain extent as a mushy moderate. And so what they see in Andrew Jackson, in him, they see a unionist from the South, from Tennessee, someone who pulled himself up from nothing, who in many ways despised the white plantation class as much as many of the Republicans. And so they thought maybe they had their man. Maybe this is the guy who's going to see to it that we punish the former plantation elites and we rebuild the conquered South. But of course they were wrong. They couldn't have possibly been more wrong, actually. But that contingency is important to keep in mind, because what we get from Johnson instead is he'll say, yes, fine, Thaddeus Stevens, Charles Sumner, John Bingham, sure. The white Southerners, they have to pledge their allegiance to the Union. They have to abolish slavery. They have to say secession was bad. But for Johnson, that's pretty much all they had to do. And, in the end, he ends up saying, white Southerners, you can have control of post-Civil War society in your states. We're going to leave it to you. And what happens? We all know what happens. They end up, from the very beginning, as soon as they're given power again, begin to discriminate against the formerly enslaved people, African Americans. They write the Black Codes into law, writing into the law that second-class citizenship. And as Frederick Douglass, among others, say, it's slavery by another name. So we have the Northerners, the party of Lincoln, the party of Union, fearing that they won the war but might lose the peace. And so what do, Kerry? They form the Joint Committee on Reconstruction in December of 1865. And so this committee is there to study what's going on in the South and figure out, what do we have to do now to create better post-war baselines for Americans? What can we do to rally the Republican Party, oppose Andrew Johnson, and set post-Civil War America on a better constitutional course? And who's the hero of our story? Well, one of the key heroes is John Bingham of the great state of Ohio. And this, I'm sorry, Kerry, yes.
I just want to make sure we got our framing right for our students. So at the end of the Civil War, we add the 13th Amendment that says we end slavery, that slavery and voluntary servitude cannot happen unless you're in a later way incarcerated. So that's the 13th Amendment. Now what we have with Bingham is the Black Codes. And for our students, could you explain what the Black Codes are? I mean, you said it in a theory. It's a way to make slavery happen without having actual slavery, but it's still enslaving people. So just give them like one moment on the Black Codes, and then looking at the big ideas of the 14th Amendment, we'll jump into Bingham, because Bingham's an awesome guy to learn about, so we want to give him some time.
Yeah, so I mean, the Black Codes are simply what they have. It's in different states in the South, and they're saying, formerly enslaved people, what you must do is you have to enter into labor contract. So there's a lot of different things, but like one of the main ones is you have to contract with, in many instances, your former masters. And if you don't, that could be a crime. We could throw you in jail. And so it's ways in which you're really forcing African Americans back into jobs, much like they had when they were enslaved people, with very lousy wages, or, if they don't want to take them, potentially throwing them, into jail, basically.
And if you were put into jail, you were basically then could be incarcerated and re-enslaved on the exact same plantation that you might have been enslaved upon years before. So either way, they're trying to force you back into enslavement in some possible way, correct?
Absolutely, absolutely. And so, yeah, so now just to get to the 14th Amendment, the 14th Amendment is a response to this state of being. It's a response to the Black Codes. It's a response to the challenge of Andrew Johnson trying to create a version of Reconstruction where, what did he say? What did he want to create? He didn't hide the ball. He said he wanted to create a white man's government. Chilling. It's absolutely chilling to think that that's what he wanted to do after the Civil War. And so the Republicans strike back. We have the Joint Committee on Reconstruction, and then we have the 14th Amendment. Who's its primary author? Who's the primary author of the words that we read at the beginning? Representative John Bingham. He's a member of the House of Representatives from the state of Ohio. To give you an idea, how do we think of Bingham? What should we think of him as? Well, the great Justice Hugo Black, who served in the 20th century, called John Bingham, the 14th Amendment's James Madison. And that's a good way to think of it. If Madison's the father of the Constitution, John Bingham's the father of the 14th Amendment. And if we're thinking of the Joint Committee on Reconstruction, scholar Gerard Magliocca, who is Bingham's biographer, said, think of the Joint Committee on Reconstruction as a second constitutional convention. It's trying to create a new constitution that takes into account everything that's happened before. So what does John Bingham write in the Constitution to the 14th Amendment? What does John Bingham and his allies in the Republican Party? Well, there are really four big ideas that unify the 14th Amendment. Four, I would say. The first is birthright citizenship. And so what's going on there? Well, Dred Scott is overturned. African Americans have rights which the white man is bound to respect. And if you're born on American soil, you're a United States citizen. This promise of equal citizenship for all. So that's birthright citizenship. The second idea is equality. Remember, the original Constitution was silent on the promise of equality, and now the Declaration of Independence was that all men and eventually all women are created equal. It's written into the Constitution. So birthright citizenship, equality. The third big idea is the protection of freedom. And what's going on here? Well, if we remember, the original Bill of Rights only applied to abuses by the national government. And so what the 14th Amendment does is it extends those rights to the states. It protects key rights like free speech and religious liberty from state abuses, the protection of freedom. So that's birthright citizenship, equality, freedom. And the last one here is that Congress, the fourth idea is that Congress is given more power. And so Congress is given power to enforce the protections that are written into the 14th Amendment. The Reconstruction Amendments are really the first set of amendments, the 13th, 14th, and 15th, that are expanding the powers of the national government. If you think back to things like the Bill of Rights, that's taking power away from the national government. The 14th Amendment and then the 13th and the 15th are all giving more power to the national government. And so here we have the 14th Amendment as, again, a story about federalism, a story about striking a new balance between the powers of the national government, the powers of the states. And the big idea here, Kerry, what's the big idea? The 14th Amendment transformed the Constitution forever. It wrote the Declaration of Independence's promise of freedom and equality into the Constitution, and it represents the heart of America's second founding.
So huge, big ideas. And for our students, that's why the 14th Amendment is so important and so often cited. It's spelling out in our legal document what are the basis of who is a citizen? So pushing back on Dred Scott, what does equality mean? What does freedom mean? What does protection under the laws mean? And then giving Congress more power than it ever had before to do this, to say, here, Congress, you're in charge. You have a duty and a responsibility as well as a power to do it. Now, so do they do it, Tom? That's, I guess, one of the first questions around this. Is when given the test, and we can jump into any court case you want to start with, but when given the test, does Congress right away take that power and use that power?
Well, Congress does for at least a few years, but then what we see is by the 1870s, 1880s, 1890s, Congress walking away, the national government walking away, the Supreme Court walking away. And so there's this weird, what we end up having is this weird separation between what's written into the Constitution, the promise that's there, and how it's actually applied in reality, and really the promise that's denied in reality. So let's again, okay, so we'll go to the march through the big equality cases here. The first one you have on the screen is Plessy v. Ferguson. It's a great one. Now, as we get to Plessy, let's remember, what is the key text? Let's rewind and say, what's the key text from the 14th Amendment with Plessy? It's that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so in Plessy, what we have is a law that's passed in 1890 by Louisiana. It's a law that says on rail cars in Louisiana, you're going to create separate cars for white passengers and African-American passengers. And in context, this is a striking thing, because Louisiana, if you think about it during this period, going back to the 1860s and into the 1870s, it's one of the places where we see true interracial democracy flourish for a short period. And so we had a Louisiana legislature with white Louisianans and African Americans coming together to write equality into Louisiana law. But as early as 1890, just a little over 2 decades after the 14th Amendment, so the 14th Amendment ratified in 1868, by 1890, Louisiana is saying on our rail lines, we're going to have different cars for whites and African Americans. And so what happens? Well, we have Homer Plessy. He's the Plessy of Plessy v. Ferguson. He's part of a committee of concerned citizens that think this law, it goes against everything we've been trying to do in Louisiana since the Civil War. It goes against everything that we see in the Constitution with the 14th Amendment and its promise of equality, and we are going to challenge it. Homer Plessy himself was a free African American, but he was someone who had a lighter skin color. And so what they were trying to do was show, if Homer Plessy just showed up on a rail car, you wouldn't know if he was white or African American. And so what they were trying to expose was this is just an arbitrary law. Who is quote unquote black under Louisiana is defined in some arbitrary way by law that's giving power to the state and giving power to local government to discriminate. And this goes against the promise of the 14th Amendment. And so what happens in Plessy v. Ferguson? We may think, of course this violates equality. Didn't we just write equality into the Constitution? How could this possibly be upheld as constitutional? But the Supreme Court, in a lopsided decision, we only have one dissenter. Every other justice of the Supreme Court says this law is fine. this law is constitutional. Who's the justice that wrote the opinion? Well, it's Justice Henry Billings Brown. He's from Massachusetts. He was a judge in Michigan. He was appointed by Republican, the party of Lincoln, Benjamin Harrison, a Republican president, Benjamin Harrison. He was on the court. Many of his colleagues who were also Republican appointed justices sign on to this opinion. And what does he say? Well, he says, you know, these laws, they don't violate the 13th Amendment, which abolished slavery. They don't violate the 14th Amendment, which promised equality. These laws are just within what we think states have the traditional powers to do. They could pass all sorts of laws that are good for the health, safety, and welfare of their citizens. And this is a reasonable regulation under that particular law. And so what we end up seeing is the Supreme Court giving a green light to Jim Crow laws like this, which allow discrimination against African Americans, and which say that effectively that if you have two separate facilities and they're equal, that's constitutional. Now, of course, we know, in fact, these facilities were never equal anyway. But the Supreme Court saying, well, if they're separate and equal, that's constitutional. And here's how Brown put it. He says that, and he blames, it's amazing. It's like he ends up, or incredible and terrible, is that he blames African Americans in part for this situation, where he says, the mistake that Homer Plessy's making in his argument is, quote, the assumption that the enforced separation of the two races stamps African Americans with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because African Americans choose to place this construction on it. So he's saying, yeah, the law is formally separate, but maybe African Americans don't want to be with white people and white people don't want to be with African Americans. The law is not really discriminating against anybody. But the last thing I'll say about Plessy Curry, and we know this, is that Brown's arguments are not unanswered. They're answered forcefully on the Supreme Court by a powerful dissent by Justice John Marshall Harlan, who again shows us that biography doesn't necessarily mean you're going to become a certain sort of justice. I mean, John Marshall Harlan was a former slaveholder. He opposed Lincoln in 1860. He opposed Lincoln's re-election in 1864. He opposed the Emancipation Proclamation. He opposed the Reconstruction Amendments, but he changed his mind. He saw what was happening during Reconstruction. He saw the violence against African Americans. He saw the ways in which white Southerners were undermining the promise of equality that we had after the Civil War, and he changed his views. And so what does Harlan say in Plessy? He says exactly what I think we naturally say to this case, which is like, Justice Brown, majority, are you out of your minds? How can you not see what's going on here? This law was written for a particular reason. What was the reason? It was to create it was to make African Americans second-class citizens in Louisiana. Once you do this on rail cars, you're going to do it in other contexts, and it undermines the promise of equality in the 14th Amendment. Here's the powerful language from Plessy. I'm going to read it just because so many people after this point rely on this language when arguing what the 14th Amendment means. He said, in the eye of the law, there is in this country no superior, dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In my opinion, the judgment this day rendered will in time prove to be as pernicious as the decision made by this tribunal in the Dred Scott case. And so the Plessy decision has. He was a prophet in that sense. And these are just powerful and inspiring words. And I'll pause there, Kerry, and then we can get into the 20th century.
Yeah, I think it's great. The only thing I would add is our students on the chat are right along with Harlan. They got it. So Erica said, what makes it unfair? Because what most of the court is saying, it's not unfair, it's equal. I mean, we know it wasn't, but even if it was, it's unfair. And she's right. It's certainly unfair. It cannot be equal. It's separate. And then McKenna goes further and says, I think it was unfair and a waste of money just to get people separated, have a separate car for Black people just because they didn't like them. And that's exactly it. That's what Harlan said. You're not doing this to separate people. You're doing it because you're saying one is above the other and one is below the other. So do not kid yourself and don't lie to me. That's why you're doing it. Inherently, when you separate, you're saying there's a difference and one is better than the other. And that is written into the law and that is obvious. So where do we see the courts finally come around and use data to say, look, we're setting up a system that shows a difference, and that's causing everybody to see that difference, even all children as well. So fast forward how many years? Almost, 65.
Oh, yeah. So we're fast forwarding to 1954. I mean, the one thing to note, Kerry, is that obviously it's not as though we have Plessy and then Brown and nothing happens in between. We
People are
have
fighting. Thank you.
yeah,
People
we
keep
have
fighting.
people fighting for civil rights. And these are people in politics. These are social movements. The early parts of the civil rights movement. Importantly for Brown, it's the NAACP and their lawyers, key lawyers like Thurgood Marshall, are putting together a legal strategy to attack Plessy v. Ferguson and attack these Jim Crow laws. And so what they do is they understand the law sometimes has to move a little more slowly than we'd like. And so they're building up precedent over time. They're attacking segregation. So Brown versus Board of Education goes to segregation, the separation of the races in the context of public schools. But what the NAACP does before that is it attacks other things. It attacks discrimination in the context of public universities. So that's McLaurin versus Oklahoma. It attacks discrimination in public law schools. And so that's Sweat versus Painter. And so you see Thurgood Marshall and his team building up legal precedents, and then bubbling underneath, you have countless Americans, African Americans and whites, saying we need to actually write equality into the law. And again, that's the key point. We shouldn't lose the key point that Harlan's making, which is you can't write that discrimination in the law. For Harlan, he may even feel some of that in his heart, but you can't write it in the law. The law must treat people equally. And that's what we're getting to with Brown. And so, I'm sorry, Kerry, it looks like you want to hop in.
No, I think that's really important because sometimes we tend to make people heroes. And when you read part of Harlan's dissent, you're like, yeah. And then you realize, oh, he didn't think this way. He was just saying in the law, it's wrong. So we need to understand the whole person and read the whole piece of it. But I just wanted to say, when we get into this Brown versus Board of Ed, Tom's going to tell you these amazing stories. You can actually listen to Thurgood Marshall speak in the court case. I will send you the link. It's one of the coolest recordings I've ever heard. It's in the Supreme Court history and their website. I'll send it to you. So hear the story from Tom and then listen to his words directly. Sorry, go ahead, Tom. Go ahead.
Yeah, no, and of course, who is Thurgood Marshall? He's the famous lawyer here. He becomes the first African-American Solicitor General of the United States, a federal judge, and then the first African-American justice, Supreme Court justice. And so he's an amazing figure. And so just to back up, so Brown, it's this large set of challenges to segregation in public schools. And it takes cases from a lot of different places, District of Columbia, Delaware, Virginia, even South Carolina and the Deep South. So you're seeing from the Deep South all the way to sort of the upper South and border states, cases from all those places. And so what's Thurgood Marshall arguing? He's arguing what you've already said in the chat when it came to Plessy, but he's arguing it here too, which is that you may have decided Plessy, but Plessy was wrong on the day it's decided. It goes against everything we know that we were writing into the Constitution with the 14th Amendment and the Equal Protection Clause. You have to overturn Plessy. You have to say separate but equal is unconstitutional in the context of public schools. And Kerry, you had sort of alluded to it, but one of the key arguments that resonates with Chief Justice Warren is it's in a footnote. So Brown's a very short opinion. I urge you all, like after this, can I give Jeff work as well?
Yeah, we all can.
Yeah, but I mean, Brown Chief Justice Warren wrote it in he wanted to be short so it could be printed in newspapers and people can read it. The other important thing is he wanted to bring all of the justices on board. Thurgood Marshall thought it was essential that the Supreme Court ruled unanimously. It's a hard case. It's a hard constitutional question for them at the time, but he wanted all of the justices on board. And so Earl Warren becomes justice midstream, a chief justice in the middle of the debates over Brown versus Board of Education. Chief Justice Vinson passes away. And so Earl Warren, who is the governor of California, a great political figure in the Republican Party, talks to all of his fellow justices and says, you must all be on board. And some of the justices were skeptical, but he would say, you don't want to be that dissenter, that people who are resisting Brown in the South using your words to advance hatred and inequality. And so Brown ends up being unanimous. And Chief Justice Warren relies in part on evidence that school segregation laws do what we would assume that they would do, which is it makes children, African-American children, feel racially inferior. It makes them feel like second-class citizens. And so in a famous footnote in Brown versus Board of Ed, he relies on sociologist Kenneth Clark's study, which showed that African-American children who are in segregated schools, if they're given a white and an African-American doll, will choose the white doll, whereas those in integrated schools would choose the African-American one. And so the idea being here that these segregation laws, they run deep into one's veins and shape who you are as an American citizen. And that denies the promise of the 14th Amendment, that promise of equality. So that's a bit about Brown. I'm happy we could sort of continue to plow ahead or pause there, Kerry.
I think Brown is one of the biggest court cases of the 1900s. So this is unbelievably huge, changes everything. It does take an unbelievable amount of work, effort, and the National Guard to start changing these things. Because with what is the line in the opinion? With due haste, we want to desegregate
deliberate
the schools.
Speed.
Deliberate speed, that's what it is. With deliberate speed, but that is still, for so many schools and so many southern states, deliberate speed is not what was meant by Warren. And it was last week, 60 years ago, that Ruby Bridges was the first elementary school child to go to desegregated school. So it's only 60 years ago.
It's not that long ago, exactly. No,
I know, it's awful to think that was only 60 years ago. So I just bring it up because it's an unbelievable story. She was 6 years old, and she was the freedom fighter desegregating that school along with her family and the work that they did. Now, fast forward to Loving v. Virginia, and we look at this story of this unbelievable family and then the fight that they had to do to stay a family.
Yeah, so this is Mildred and Richard Loving. This is 1967, so it's a little over a decade after Brown. And so what they're doing is they're just two people that love each other and they want to get married. They live in Virginia, and Virginia has a law in the book saying that people of different races can't marry. Now, of course, these laws go back to the 1800s. In 1967, there's still, I have it written here, 16 states that have these bans on interracial marriage, 16 states. And so Mildred and Richard Loving are saying two things. They're saying, one, this is clearly a violation of the 14th Amendment's Equal Protection Clause, but it's also a violation of our freedom to marry. For them, the marriage is a core right that is protected by the Constitution under the 14th Amendment. And so that it's a violation of equality, but it's also a violation of one of the core freedoms that we have as Americans. And what does the Supreme Court say? Well, the Supreme Court says Mildred and Richard Loving are right. The the ban on interracial marriage, it's unconstitutional. And Earl Warren, here's how he puts it. The freedom, it's an opinion written by Chief Justice Earl Warren, and it says the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. The pursuit of happiness. It's Earl Warren extending the right to marry all the way back to the Declaration's promise that all men and women are created equal, and then that's written into the Constitution with the 14th Amendment. And he said to deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these laws, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state citizens of liberty without due process of law. So that's Loving, that's interracial marriage. What we see fast forwarding ahead to 2015 is that the Supreme Court is then asking the question, does Loving apply to same-sex marriage? So again, we have same-sex marriage bans in states throughout the country, and the Supreme Court has to ask, does the 14th Amendment do we have to strike down these bans on same-sex marriage as a result of the 14th Amendment? And in part, what you see in the court's opinions, that it's a 5-4 decision, so it divides the justices. And so what you see, the majority of the dissent are arguing over two big things. One, what does the 14th Amendment do? What does it protect? What does its promise of equality mean? But two, what is the meaning of Loving v. Virginia? Can we, in effect, compare same-sex marriage bans to interracial marriage bans in the 1960s? And the justices disagree on this, but a majority of the Supreme Court, that 5-4 majority, say yes, Loving applies in this context. The 14th Amendment attacks bans on same-sex marriage, and therefore same-sex marriage bans are unconstitutional. But again, it ends up dividing the justices 5-4. But it's again this way in which so many of the issues that we care about end up being a battle over the 14th Amendment's meaning, in this case, the Equal Protection Clause, but then also key cases that came before, whether it's Brown, whether it's Loving, these cases that are part, or Plessy going all the way back, but these cases that are part of the line of cases about the 14th Amendment, we debate over what they mean, whether they were right, how broadly they reach. And so anyway, I'll pause there. I could go on and on, obviously.
I think that's really great for our students to understand. It's not just looking at what's written in the law or in the Constitution, but what's decided in the courts. And those two pieces together can help us define how the courts are making their next choice and their next decision. So when you say there was a 5-4 split, so what were some of the points on the for side? Like, why did they say it wasn't like Loving and this was equal protection of your right to life, liberty, and pursuit of happiness?
Yeah, and it's really interesting. All 4 of the dissenters write separate opinions, so they all felt like they had something to say about this issue. That's unusual. Some of them joined the others, but there were 4 opinions written. One of the arguments, and Chief Justice Roberts really stressed this in his dissent, is that he said, this is an ongoing constitutional debate that we see in our country. People are changing their minds. We're seeing, and he acknowledges, the law is moving in the direction of those who support same-sex marriage. But there's still a lot of people who disagree. And so this is a quintessential question that should be left to the elected branches to decide over time. And so Roberts' opinion really is an argument about what you would say, who decides this issue? Is it the court or is it the elected branches? You see some other, Robert says some of the other dissenters do also just say, like, look, there's a way in which race is a distinct problem in American history. It's so like loving should be restricted to that context. The 14th Amendment was quintessentially about taking away racial discrimination. And so we should be careful before moving on to, other areas, other people who are laying claim to it. That's one. The other is that, the tradition in this country has always been marriage between a man and a woman. And so, that to continue to believe that is a rational belief that we should allow, again, the elected branches to make that decision one way or the other.
Got it. So again, federalism in a way is what they were saying, a few of them.
Yes, absolutely.
States to make these choices. So 4 big ideas coming from the 14th Amendment: the right to have citizenship, because where you're born in America, that's birthright citizenship; equal protection, protection for freedom, and Congress is given more power. So Tom, do you want to just sum us up with one more time the big idea of the 14th Amendment that students can take away?
Absolutely. It's exactly what's there, which is that if there's just one idea, I think it's that the 14th Amendment transformed the Constitution forever. And so how did it transform it? Well, it wrote the Declaration of Independence's promise of freedom and equality into the Constitution. And it's at the heart of America's second founding. And so what you end up seeing, Kerry, is from Plessy with race to Obergefell with LGBTQ couples to, we didn't get to them, but the whole string of cases where you have then lawyer, the late Ruth Bader Ginsburg fighting for the 14th Amendment to apply to women. This form of argument going from the 1870s all the way a century later to Ruth Bader Ginsburg arguing in the 1970s, the 14th Amendment must apply to women, and onward and onward. The 14th Amendment becomes a main way in which we debate so many of the constitutional issues that we care about most.
Awesome. Thank you so much, Tom. We're going to wrap up. If you do have questions that you want to hang out with us after hours, we do have a 5-minute office hours, I should call them. But thank you guys so much. It was fun to have you in class today. Have a great day. And on Friday, we are having Professor Kate Mazer join us to talk about modern cases around the 14th Amendment. So if you want to keep going here, we'll see you Friday, 1 o'clock Eastern time. Thank you very much. Bye-bye.
Thanks, Julie.